We are live.
We're back in Senate Judiciary. It's April 21st. We are now taking up page 937, which is the miscellaneous judiciary bill. We have the judiciary here to answer few different questions. Based on some of the past testimony, they've had a couple of questions in a few different sections, and the floor is all yours.
Great, thank you, Chair Person, State Board Administrator. I just wanted to explain that we heard in listening to testimony about page 937 last week that there were just some various miscellaneous questions that Judge Somebody thought it might be helpful to provide at least the information we have on it, if that's helpful to you all. But first, we're starting in section 2, and this has to do with misrepresentation of age statute, and there was a specific provision about the impact of the suspending a person's license. And the question was, what would happen if the person didn't have a license, either because they were underage or they just simply didn't have a license? And ultimately, it would be the Department of Motor Vehicles that would decide that question. It's not something that the judiciary necessarily provide insight into, because they're could be a project of the court using the interpretation of the DMV's authority in that regard. So sorry to not have a more clear, but the question was whether the judiciary would have an opinion that since the DMV would be the one imposing it, we wouldn't be able to, I guess, give an opinion, and would recommend they'd be asked if they have questions about the practical effect of that from their perspective. That's section 2, which is pages 4 to 6.
Senator Matos, you want to hear from the DMV?
I would be curious because I think it rolls over to section 3, right? No, that'll be sorry.
Yeah, because it would be.
Yeah. Yeah.
Henry, could you please reach out to DMV? Not sure who. Perhaps if you could start connecting. You want to start with her and see where we can find an answer for this. That's great. Thank you.
I don't think she's commissioner
No.
anymore. She's building new grounds now.
Okay. Well, whoever the commissioner or deputy commissioner is. Thank you. Okay.
And then there's this section 4, which is on page 7. And this has to do with dissemination of electronic case records. In particular, right now, there's a statutory prohibition of putting access to family probate or criminal records. And the proposal was to remove criminal from that prohibition. There's an effective date of July 1, 2027. So, and the John pointed out, the rules of maybe would ultimately answer some of these questions, but Senator Norris had asked if there would be a fee for the remote access. And currently, we don't have a fee for access to civil and JV records, which are available over the internet. I wouldn't anticipate that we would have a fee. We don't typically charge for electronic records being provided. If somebody's at the court now and requests a copy, there's a 25 cents per page fee, the dollar that's a statute. So to your point, I think the rules committee would address that, but I would anticipate that they will, because we provide electronic records.
But someone had mentioned that there was a computer in the courtroom that could go and have access to the computer or whatever else for public records, whatever else. But if they wanted to print something off the computer, that's still going to be related.
Oh, yes. I mean, if they ask the court to print off a hard copy or a copy, there would be that fee. But I think the idea would be for people to be able to access the records remotely from their desktop. Or, for example, the court emails something to somebody, they don't charge for that. It's basically the cost of the paper because we have to justify any fee with whatever the cost is.
Yeah, I just think like when I go to look at the land records, it's $1 a page if I print at the town clerks, or if I go online to the online system, if it's through NAMRIC or something, and then it's $3 a page because I think they sink the cost of the system into the printing of it at home, whether it's PDF or on a hard form. So this would be, it's 25 cents currently if you print something in the system at the courthouse. Can they PDF it to themselves, or is it just printed?
Not currently, the public portal at the courthouse, there is an ability to email it to themselves, for example. We are having, there's an upgrade, if you will, through the public portal, and that was one question we had, whether more people could just email themselves copies that way, and that's remains to be seen. But currently, with the way it's set up now, you're not able to email it to yourself. But if this, you know, if you could access your normally, you have access to it, you can print it off where you are. Like that.
With no charge?
No charge, we just haven't, we never charge for electronic access.
Terry, I'm looking at page 7,
Uh-huh.
and this is my own influence here. It says the court standing language is court shall not permit public access via the internet to criminal records. Now we're eliminating criminal. Does that mean that the public will have access to criminal records?
Yes,
Okay, and then on the next page, it says licensed Vermont attorneys in good standing will now not have access.
oh, they changed it last year so that attorneys could have access to the criminal records for a variety of reasons. I think Senator Hashim was he might have even proposed them initially. So they do, but this would be for the members of the general public having access to criminal.
I'm, so they,
If you're saying why cross it out there?
yes,
I think the idea, because of the effective date being July 1, 2027, this would be to allow licensed attorneys to have it now.
Yeah, I mean, the way I'm understanding it is if everybody is going to have access to it from their desktop at home or at their office, that would also include the attorneys who currently have access to it. And so this becomes moved off line 4, right?
And they would also still have access to family probate case records, whereas the members of the general public would not.
okay, yeah, it was just, it seemed that we were giving it to non-attorneys and taking away, but they have it.
Yes.
Okay,
And then I guess the other, question I think, you had asked whether or not it's like the land records. Similar in terms of being able to do research online, but there would not be a charge that I didn't realize some folks charge even if you're not able to access it. So that'd be kind of similar to the federal court system where you have to pay even though you're accessing it, you're printing off and
Yeah,
so,
I think it's kind of like user fee for the use of being able to sit there.
So, and we are setting up a subcommittee through the Public Access to Court Records Committee, to address these rules. I had informed them about this bill, so basically I think we're waiting until it passes and then the subcommittee will be set up so that people can basically formalize all these details. And, otherwise figuring out just from the kind of the, with the new platform that they're on as well, making sure that's all the services.
Then what's your printing budget? Like how much revenue do you earn off of that kiosk?
The copy, I don't know for a fact, I'm gonna say not substantial, but I don't honestly know. I can check how much revenue is generated with copy fees.
Yeah,
Yeah, you would have more, we also have copy fees for certified copies, for example, that might be $15, I don't know. That's more substantial than the 25 cents a page, but, I will find out.
I'm just curious.
Yeah.
Don't want to create a hole, like.
Yeah, although I think the convenience for people will be, it's powerful decisions for the legislature, but I know people are interested in the media, especially. But we do have a media representative on the Public Access to Court Records Committee, and I'm sure they'll probably focus something into it.
Because it costs not like the town ones, it costs nothing to go look. It's just until you print it for your own records that it costs money. So like the media could still spend $0 if they didn't want to have a copy of it, or anyone for that matter, but just like
Yeah. I'll make sure that some committees are aware that you have the question and it's what they want to do, but I know we don't charge for the citizenship access. Sure.
Were there other sections too?
There was one other one then for sections 8 and 9. And this had to do with amending the civil and criminal stalking definition to clarify that course of conduct shall not be required of the 2 or more acts occur on separate calendar days. And I guess the point we're making there is that the statutes don't require the 2 separate calendar days as it is. So we just wanted to point out that there isn't that requirement currently. It's fact driven, and the court will look at, whether the criteria are met, including 2 separate, occasions. But there isn't a requirement now that it'd be on 2 separate days.
Yeah, that's what I thought too, based on how I was reading the language. And then I think we heard that there was an anecdote from another legislator that there was an issue with that somewhere. I don't know.
That was interpreted.
Yeah.
Not required to
Yeah.
separate days. Oh.
Yeah, so I don't know if that's a thing that happened, or, I mean, I don't want to legislate things just on an anecdote, from an unknown legislator. And if it's currently being interpreted that's already the rule, that it doesn't require 2 separate days. I would be hesitant to make that change if it's already being interpreted that way.
Okay.
Yeah.
That's my understanding, that there's a requirement of 2 separate days, and that's what Judge Zoning also indicated. So unless I don't know, if there wasn't a case where somehow that was specified, but I'm not aware of it.
Yeah, because then what I'm worrying about is in other places of law where we don't make this distinction, if a judge may say, all right, well, the legislature specifies in the stalking statute, but they, regarding this language, but they didn't specify in this other area.
Right.
Therefore, it does have to be 2 separate days. I worry about that issue. So, yeah, any thoughts? Questions?
Is it possible to ascertain in the legislative was so we can find out what the religion?
My recollection, I don't know, so I'm just picking up this bill now, but my recollection was that, and I don't know, that it was, Representative Harvey in House Judiciary who brought this issue.
Sadly.
So, but I think, I don't know, I would agree with you in terms of there's nothing in the statute that requires that, and it's fact driven regarding each individual circumstance for the course of conduct.
I'm happy to check with him if you find.
Yeah, if you don't mind. And yeah, I just worry about affecting other statutes and interpretations if we are making that distinction in this language here. So, and if it's an unnecessary distinction to make, then I would recommend removing it, but I think we'll wait for a little bit and see what Representative Hardy has to say.
Okay, I can go to the share again, right?
Great.
But those were basically what, at least as far as we knew, the questions that there were that we wanted to just.
Thank you. No, it's all, appreciate it. Committee, anything else?
Wanted to, once everybody's done, I wanted to read something off Barry's there to circle back on a question that somebody was we had last time. So
Anything else, committee, or?
So I believe when Eric was in here doing the walkthrough last week, and you'll recall that in section 3 of 937 as it passed the House, there's it's amending the alcohol, the underage alcohol statute with regard to underage possession and putting forth a big ID. And my understanding was that this was a recommendation just with the General Assembly to look at the issue about whether or not there should be a minimum age requirement for that statute that is modeled after what you have for underage possession of alcohol or using big ID to buy alcohol, which does have a 12-year-old, and so goes from 12 to under 21. But it's a minimum age, and so House Judiciary. And I think the way that originally the court had presented it was, we're not sure if this is a so, like an intentional difference between the underage tobacco and underage alcohol statute with, because the tobacco one just says under 21 right now and has no minimum age. And I believe that Judge Zonate had provided an example where a 7-year-old perhaps was provided with a ticket. And so House Judiciary just established the language that you have in section 3 here, which just sets the minimum age of 12 years old, modeled after what you have for underage alcohol. And then Senator Bohosky said, oh, in another committee, in another bill, that section was amended. And so I kind of followed the thread. That same section of law 7 VSA 1005 is in S198 with regard to a number of tobacco issues. It does make substantive, as opposed to this, which in some ways you could say is somewhat of a technical amendment by establishing the 12 years of age with regard to that's when, you could be subject to delinquency. Is that other amendment in S198 actually removes the offense of possession, which is a civil penalty under existing law on tobacco. And then it increases the civil penalty for using a fake ID device by tobacco from $50, I believe, to $100 for the civil penalty. So it makes some kind of policy substantive decisions that was made a couple doors down. That bill is now in Human Services. I reached out to Jen Harvey, because she's the one who is handling S198. So we at least know about it. And I think what we decided our recommendation would be, but totally up to y'all, is that whatever decisions are made in the tobacco bill. And she knows about this provision in here about establishing the minimum age of 12 years old. And she'll talk to the chair of Human Services around that. They're not sure if they're going to keep the Senate language on that at all, but we're just thinking it might be a lot easier for us all to track and follow, because these two amendments, I believe, as Eric testified last week, sometimes if there's two acts that pass and they amend the same section, we can, through, our summer work, whatever, kind of marry those together. But where this is changing it to 12, all that's repealed, and so it doesn't really work. It doesn't really work that well. So it should all just be in one location, if that's okay with y'all. So I would recommend taking this section out and just having those decisions be done in the tobacco bill. If somehow the tobacco bill doesn't look like it's going to make it, or they take that whole section out, or don't want to do that, you could always add, this bill being around. So, but it's your decision. But we just don't want to wind up at the end with conflicting provisions.
So if recommendation from Ledge Council is to strike a section, making sure that that's.
Yes.
Yeah, okay.
Yes, and that, we'll make sure it's communicated to the House, and then also to Senate Health and Welfare. That was the one that were the best one I gave. Is
that a hand in support of striking it, or do you have?
Not necessarily.
Okay.
Yes, I do. Question, comment. So my hope when that bill, when S198 was on the floor, is that we actually add in these types of tobacco offenses to the youth substance safety program for the sort of that restorative justice and treatment arm.
Mm-hmm.
When I dug into it with Jen Harvey a little bit, it seemed too complex to do as a floor amendment. And so I'm wondering from your perspective, if you were to dig into that aspect of this, so treating tobacco offenses the same way we would treat underage alcohol possession or underage cannabis possession, would that still be in conflict, or would it be possible? Because I think that discussion about restorative justice and probably should happen.
Mm-hmm. Because what I'm asking makes sense. I know what you're saying. So you're looking at kind of addressing an issue that's not in either version right now. And I think, you know, you could certainly do that in here and leave this here, and then we could just let things percolate and see what they do with that section over in the house. You know, the issue would just be that I think we just want to make sure that we either, if there's going to be provisions in both bills, that they can be combined in a way that makes sense, or that they have at some point have the same language, or, you know, that kind of thing. Because on the S-198 language, because it does remove an offense. I mean, I think there's a way we can figure it out. So, so it's up to you. Again, you can ask the health and welfare committees to deal with this larger issue if you want to talk to the House in there, or if you'd rather do it here. I'm happy to do whatever you want. I just want to make sure you knew that we were following up on what the issue that you had raised. And, but it does get a little messy at the end there when so many things are moving. We try not to be amending the same section and multiple bills, because if you get lost.
Yeah, no, I appreciate that. And I certainly, like I said, you know, flag that because I'm sort of aware of that. But I do think it is an opportunity for us to have a conversation, and whether they do it in the House or we do it here, about, you know, one of the things I've said on the floor when the tobacco bill was presented is that we want to get kids into treatment. And if that's what we want to do, we should use the existing structures we have for other underage substance use to get kids into treatment.
So you'd like to keep the language?
I don't want to keep exactly this language, but I want to have that conversation about expanding. I'm trying to find what it's called, but the program that we use for underage.
It's changed the names a lot of.
Yeah, that's why I can't think of the name of it.
But whatever. Right.
The Youth Substance Awareness Safety Program.
ISAS.
YSAS, I guess.
Thank
What I'd like to see us consider is expanding that to include to have the kind of same structure for tobacco. It just makes sense to me. And again, if we do that in here, cool. If we do it over there, also cool. I just want to do it.
I feel
And
like we had that similar conversation on the same topic like a year or two ago.
We did.
Yeah.
I feel like.
okay, well, I brought it up on the floor when the tobacco bill came through.
I think that's one of those.
And like I said, my intent had been a floor amendment, too complex for a floor amendment, but now we have this other opportunity to dive into complexity and maybe do it. So that's my sort of long way of saying it. I understand the language in here as it is conflicts, but I think there's a way to maybe massage it to address this issue rather than simply striking it off.
Sounds good. We'll revisit that. And if you have proposed language that you want to add to bring in for discussion, we'll do that. All right.